Welcome to the Judicial Committee of the Privy Council. Today we are hearing an appeal from the Supreme Court of Mauritius in the case of Betamax Ltd and the State Trading Corporation. The appeal concerns an arbitral award arising from a claim for breach of contract and the judgment of the Supreme Court to set aside the arbitral award on the ground that the contract was contrary to the public policy of Mauritius. Today, the appellant's case is presented by Mark Howard QC and Salim Mulan QC, assisted by Siddharth Da, and the respondent's case is presented by Alan Tu Choi QC, assisted by James Guthrie QC. Before inviting the appellants to present their appeal, I will introduce the members of the board. I am Lord Hodge. Lady Arden? Lord Leggett.
Good morning.
Lord Burrows.
Good morning.
And Lord Thomas.
Good morning.
I now invite you, Mr. Howard, to make your submissions.
I'm grateful, my lord. As your lordship knows, this is an appeal against the judgment of the Supreme Court dated the 31st of May 2019, whereby the Supreme Court set aside the arbitration award dated the 5th of June 2017 on the ground that the award was contrary to the public policy of Mauritius within the meaning of section 39 subsection 2b2 of the International Arbitration Act, or IAA. By the award, which is at page 90 of the bundle, we don't need to turn it up, the arbitrator, Mr. Michael Prowse, had found that firstly, he had jurisdiction to decide the claim. Secondly, that the STC, the State Trading Corporation, had repudiated the contract of affreightment, or COA, dated the 27th of November 2009, and was liable to Betamax for damages in the sum of $115 million odd, plus interest and costs. Now, the COA had operated smoothly from its award in November 2009 until the beginning of 2015. There was then a change of government in Mauritius. The new government, when in opposition, had opposed the award of the COA. Having won the election, it purported to terminate the COA. Now, numerous arguments were raised by the STC before the arbitrator as to why it said that the dispute was not within the jurisdiction of the arbitrator, or either that the STC was not bound by the COA or was entitled to terminate it. Most of these points have fallen away. The only matter that remains in dispute is whether the COA was entered into in breach of the provisions of the Public Procurement Act of 2006, the PPA, or whether the PPA did not apply to it, as the STC was excluded from the application of the PPA in relation to such a contract. And in particular, was the COA the type of contract in the first schedule to the Public Procurement Regulations 2008 as amended? I'll call those the regulations. If so, notwithstanding section 3.2 of the PPA, which provided that the PPA did not apply to such a contract, was the effect of a saving provision, regulation 2A in the regulations, which introduced the new definition of exempt organization, was the effect of that, but nevertheless the Act did apply, thereby, in the words of the Supreme Court, annihilating the exemption. Now, the arbitrator, the learned arbitrator, held that firstly, the COA was a contract of the type in the first schedule to the regulations. That's at paragraph 157 of his award, page 133 of the bundle. And secondly, that regulation 2A did not apply to annihilate the exemption, and that's paragraph 161 of his award, page 134 of the bundle. Now, the argument that the arbitrator did not have jurisdiction to determine the disputes is no longer live, it is common ground now that the disputes did fall within the jurisdiction of the arbitrator. Now, just by way of introduction, under the IAA, the Arbitration Act, the International Arbitration Act, the aim was to promote the use of Mauritius as a jurisdiction of choice in the field of international arbitration. Under that act, there is no right of appeal, including on questions of law. So it's different to the Arbitration Act in England. And the Act provides in terms that an award should be final and binding with respect to the matters determined therein. Now, notwithstanding that, the Supreme Court decided that it was open to it to review and overturn the arbitrator's conclusion that the COA was not entered into in breach of the PPA. Having so concluded, the Supreme Court then held that the award was in consequence contrary to the public policy of Mauritius and so liable to be set aside. As your lordships and ladyship know, we challenged the Supreme Court's judgment on 3 grounds. Firstly, that it was inappropriate for the court to conduct a de novo review, and that the determination of the arbitrator on the question whether the COA was entered into breach of the PPA should not have been reviewed. That was a matter for the arbitrator, and his conclusion on the matter was final and binding. Secondly, in any event, the decision of the arbitrator was plainly correct. The PPA did not apply to the STC in relation to the COA, and the Supreme Court was wrong, even if it were appropriate to go into the matter, to have considered otherwise. In any event, thirdly, even if it were correct to review the matter de novo, and even if it were correct the COA was entered into in breach of the terms of the PPA, it did not follow that the award was contrary to the public policy of Mauritius. It was not. Now, I propose first to show you the relevant legislation and to consider how it developed in the period leading up to the conclusion of the COA. In doing so, and for convenience, I will make my submissions concerning the construction of the PPA, notwithstanding my overarching point that the decision on these matters was a matter for the arbitrator and for the arbitrator alone, and not an area into which the Supreme Court should have trespassed. Obviously, if I am correct on the true construction of the PPA, that is itself sufficient to establish that the decision of the Supreme Court was wrong and should be reversed. Having dealt with the PPA, I will then revert to the submission that in any event, the Supreme Court should not have sought to review the matter de novo and should have not trespassed into this area at all. And as I've said, finally, Mr. Moulin will address you on whether the award was in fact contrary to public policy, even if the COA was entered into in breach of the provisions of the PPA. Now, and again, by way of introduction, on the last point, it is important to note and bear in mind the following at the outset. Firstly, the contract of affreightment, the COA, was entered into in circumstances where everyone involved considered that the provisions of the PPA did not apply to it. That is to say that STC was excluded from the application of the Act in relation to such contracts. The everyone I refer to in this context constituted the government, the STC itself, the law officers, and Betamax and its officers. In other words, if there was a breach, it was entirely innocent and inadvertent, a point which is now, contrary to the position taken by the STC below and in the tribunal, that is now common ground. Indeed, it is noteworthy that even after the COA had purportedly been terminated, it remained the view of the STC itself and of the Procurement Policy Office and of the DPP of Mauritius that the PPA did not apply to the COA or similar contracts. We know that because the STC itself said so when seeking replacement contracts. See, for instance, page 1679, which might just be worth at this point turning up. You'll see this is the STC subsequently seeking bids for replacement contracts of affreightment. And you will see that in the introduction, it is said, firstly, it explains what the STC is, and I'll come back to that, but it's worth picking this up at the moment, that it's the trading arm of the government of Mauritius, responsible for the importation of essential commodities, such as petroleum products, LPG, wheat flour, and rice, with a turnover of $1.3 billion. And then the next paragraph, although it is a public body, the STC is exempted from the provisions of the PPA by Government Notice number 68 of 29th of June 2009, and that was the amendment to the PP regulations in respect of procurement of goods destined for resale. The exemption applies equally to services incidental to the purchase or the distribution of such goods. So, notwithstanding the position that they were taking in the arbitration, STC's position, in fact, remained both before the contract of affreightment and was entered into, and after they repudiated it, that the PPA did not apply. The Director of Public Prosecutions himself reached exactly the same conclusion in relation to potential charges, and that you'll see at 1854 to 5 of the bundle. Don't need to turn it up at the moment. Now, the next point in relation to this to bear in mind when considering this question of public policy, contrary to the view expressed by the Supreme Court at page 246 of the bundle, and based on the submissions that were then made to it by the STC, any failure to comply with the Act does not constitute a criminal offence. Indeed, that is now common ground, and it will only constitute a criminal offence if that is done intentionally. And as I say, it's now accepted there was no intentional breach of the statute. There was a breach. Any such breach was innocent and inadvertent. The next point to bear in mind, which again is common ground, the PPA does not in terms provide that any contract entered into in breach of its terms is void or unenforceable. Of course, if that were to be the intended effect, one would have expected that's what Parliament would have prescribed. Indeed, as I will show you, the scheme of the PPA recognises that a contract which may not have complied with the terms of the PPA will not ipso facto be void. Now, in our submission, that is not fertile ground for a finding that an award giving effect to a contract which for this purpose has been entered into innocently in breach of the terms of the PPA is contrary to the public policy of Mauritius. Now, my lords and lady, before considering the PPA, can I say something about the COA and indeed how the STC operates? As you've seen from that document I showed you a moment ago, the STC is the trading arm of the government, and it is responsible for the sourcing and importation of essential strategic commodities. And you saw the ones that were identified: petroleum, LPG, rice, and flour. And the purpose of that is to cater for the needs of the domestic market. Now, the government, prior to 2009, was keen to have a vessel dedicated to carrying petroleum products to Mauritius because it wished to avoid dependence on foreign suppliers of freight services. Now, the COA represented the means to achieve this end. It involved Betamax, which was a joint venture between Betamax, a company within the Mauritian Bunjung Group, and Executive Ship Management Pte Limited, a Singaporean specialist company providing ship management services. As you've seen, the COA was for a period of 15 years and provided for the STC to be entitled to 100% of the freight capacity of the vessel and to pay a fixed freight rate, which was subject to an escalation right. It was subject to arbitration under the rules of SIAC, the Singapore International Arbitration Centre, but otherwise subject to Mauritian law. Now, the STC imports all the oil that is required for consumption in the Mauritian domestic market. It sells that oil to the oil majors, who pay via a form of transfer pricing the CIF price for the oil, plus various duties, plus a charge for STC's operational expenses. That wholesale price is then subject to an uplift for the oil company's operational expenses and wholesale margin and VAT, and the price at a petrol station is then subject to an uplift for retail margin. All of that methodology is set out in public documents of the STC on its website if you were interested in looking. Now, the PPA. The PPA came into force on the 17th of January 2008. The precursor to the PPA was the Central Tender Boards Act, which was repealed by the PPA. The earlier act, the Central Tender Boards Act, only applied to the STC insofar as it was concerned with civil engineering works and capital goods. So it would not have applied to a contract such as the COA. Now, as I'm going to have to show you, the PPA during the period 2008 to 2009 evolved and changed, and it evolved and changed in some material respects. Your lordships and your ladyship are obviously concerned, as was the arbitrator and the Supreme Court, with the position in November 2009 when the COA was entered into. Now, we have yesterday submitted an additional bundle which contains the consolidated version of the PPA and the regulations in the form in which that was submitted to the Supreme Court in 2009. I will be taking you to the legislation as it evolved, but just for present purposes, so you can see the form of the Act as it stood at the date of the COA, I would refer you to that. That's in the supplementary bundle, and the relevant section that one's concerned with is at page 19 of the supplementary bundle. And in order to understand it, you need to go back to page 16, which is where section 3 starts, which is the application of the Act. And section 3 then explains where the Act applies. We're not concerned with section 3.1, which is largely dealing with national security and defense contracts, which don't apply here. We're concerned with page 19, which is section 3.2. And so you can see that the Act, as it stood at the date of the COA, provided that this Act applies to any other procurement effected by a public body other than an exempt organization. Now, an exempt organization was defined in the statute and if you go back to page 13 of the statute, you'll see an exempt organization was defined as a body which is by regulations excluded from the application of the Act. And the relevant minister had the power to make regulations. Now, so the regulations which then one is concerned with are the public procurement regulations. Now, at the time of the entry into the COA, the regulations had been amended, and they provided, and you can see this in this bundle if you turn to page 75, which is the consolidated version, page 75 contains the amended definition, and we'll see what the original definition was in a moment, of exempt organization. And so you can see the amendment exempt organization on page 75 means a public body which is excluded from the Act in relation to contracts referred to in the first schedule. And the first schedule is at page 117. And you'll see in the first schedule that what you have is a list of bodies, of public bodies, and then you have a list of types and of contract. The State Trading Corporation appears in part 1. In due course, we'll have to look at the other bodies. While you have pages 117 and 118 open, at the date of the entry into force of the COA, November 2009, State Informatics Ltd, who you see in part 1, they didn't feature. They were added, as the document shows, in 2016. Then on page 118, you can see that the legislature added additional bodies and additional contracts at later stages. So in part 5, the Competition Commission of Mauritius in 2012. In 2017, you can see they added a provision for any public body in respect of contracts which were being financed by a foreign state. And then part 7 dealt with National Assembly. Now, the issue, as I've already explained here, in relation that arises, is the COA encompassed within the type of contract which you see in part 1, namely goods purchased for resale, including services incidental to the purchase or distribution of such goods? Does it fall within that description? Now, procurement, or if we go back now to section 3.2 for a moment, so if you go back in the bundle to page 19, and to remind oneself that the Act applies to any other procurement effected by a public body, procurement is then a defined term, which you will see on page 15 in this supplementary bundle. And you'll see at page 15 that procurement means the acquisition by a public body by purchase, lease, or any other contractual means of goods, works, or consultancy or other services. So basically, procurement is by a contract acquiring goods, works, consultancy services, or other services. So the effect of section 3.2 is that the Act applies to acquisition by a public body by any contractual means of goods, etc., but not to contracts of the type specified in the schedule to the regulations. That's just the plain meaning of section 3.2. When you read, going back to page 19, if one then reads in the definition of procurement and the definition of exempt regulation. Now, the question, therefore, that arose before the arbitrator was whether the COA was a contract of the type specified in the first schedule to the regulations. Now, the Supreme Court did not consider this point because it considered the question did not arise because of the effect of, as it saw it, of Regulation 2A of the regulations, and that you'll find on page 76. This we'll see how this came to be introduced at the end of June of 2009. So when the regulations were amended on page 75 to change the definition of exempt organization and to introduce the schedule, they also introduced paragraph regulation 2A. Nothing in these regulations shall be construed as excluding the application of the Act to a public body referred to in the first schedule to these regulations and the schedule to the Act in respect of a procurement contract to which the public body intends to be a party and which is specified in column 2 of the schedule. Now, column 2 of the schedule we'll come back to. That is the schedule to the Act. As I say, the Supreme Court didn't consider the exemptions provided by the first schedule because it said regulation 2A, and this is the word it used, annihilated the application of any exemption under the regulations in relation to any of the contracts referred to in the first schedule to the regulation, where the intended contract is one that fell within column 2 of the schedule to the Act. Now, the schedule as it stood in November 2009, and for this purpose I'm going to go back to the original bundle. And I apologize, it's slightly confusing that you have to jump from schedule to schedule, but in order to understand these points, I'm afraid you have to do it. So the schedule, my lord and lady, as it stood in November 2009, will be found at 2762 of the bundle. So this is the schedule to the PPA. Now, it got amended. This schedule that I'm showing you at 2762 was part of an amendment to the Act, which was introduced in the Finance Act of 2009. And you can see that if you turn back to 2674. In fact, it's not the Finance Act, it's the Finance Miscellaneous Provisions Act of 2009, which was gazetted on the 30th of July 2009. This Act made, as you can see if you look on page 2674, it was an act to amend a whole host of pieces of legislation. And on page 2675, you can see that the Public Procurement Act was amended at item 35, and you will see the amendments at page 2738, and we'll come back to how these amendments worked. But pages at section 35 at page 2738, they amended the Act in various respects, and they at 2739 at 35 sub paragraph H, they repealed the schedule to the Act and replaced it with the schedule set out in the fourth schedule, and that is what you have at 2762. So if you could just bear in mind, these are quite difficult concepts to keep in one's mind, regulation 2A referred to the schedule to the Act and was a saving provision in respect of that. It referred to procurement contracts specified in column 2 of the schedule to the Act. At the date of the COA, the contracts which it was referring to are those at page 2762. So, as you see here, the scheme was that you have column 1 is the public bodies, column 2 is the type of contract, and column 3 is the prescribed amount. And the prescribed amount identified whether a contract was a major contract, in which case it wasn't that meant it was subject to the PPA, but it meant it was subject to additional provisions of the PPA, which applied to major contracts. And so you can see, looking at that the public bodies are listed. You can see different types of contract. If you go to page 2763, you will see three bodies mentioned. On page 2762, could I draw your attention under column 1 to other parastatal bodies not specified in parts 2, 3, 4, and 5? Could you just note that one? The reason I'm asking you to note that, there's a body called ICAC, which we're going to come to in a moment, the Institute Against Corruption. That is an other parastatal body not specified in parts 2, 3, 4, and 5. On page 2763, under part 3, you'll see in particular, note the Agricultural Marketing Board, the Mauritian Examinations Syndicate, and the Outer Islands Development Corporation. And you can see that types of contract referring to them are goods, civil engineering works, and capital goods, consultancy services, other services. And then, as it happens, 50 million rupees for each of those. Then in part 4, you have another list of bodies. And if you go to 2764, you will see part 5, and you'll see the Central Electricity Board, the Mauritius Broadcasting Corporation, and the State Trading Corporation. You see the types of contract for them and the prescribed amount. Now, the reason I've drawn your attention to all of that is what one needs to bear in mind when one is considering this is you have to go back to page 2672 and 3. So 2672 is the regulation which was gazetted number 68 of 2009, which was the amendment to the procurement regulations. And we'll come back to see this in a moment. But you'll remember here you see under Regulation 3, the definition of exempt organization, which I've already shown you, which found it's what goes into the regulation because this was amending the regulations. And at page 2673 is the schedule, which is referred to, of the contracts where the public body is excluded from the application of the Act. So if you look on that schedule, you'll see that under Part 1, each of the Agricultural Marketing Board, the CEB, the Outer Islands Development Corporation, and State Trading Corporation are exempted in respect, or the Act is excluded from its application to them in respect of the contracts, of goods purchased, and so on. ICAC, the Independent Commission Against Corruption, all contracts. Then the Mauritian Examination Syndicate, goods purchased including services relating to or for the purpose of holding of exams. Mauritian Broadcasting Corporation, purchase of films or acquisition of transmission rights. Now, the thing to note at this stage is all of the contracts, types of contract which you see on page 2673, all of them is either a subset of the contracts which are on pages 2762 to 4, or entirely overlap. Now, why do I say that? In 6 cases, they are subsets, because if you look at the Agricultural Marketing Board on page 2673, and Central Electricity Board, Outer Islands Development, State Trading Corporation, goods purchased for resale, including services incidental to the purchase or distribution of such goods, is plainly a subset of, if you go to page 2764, of the types of contract there, namely goods, amongst other things, or other services. But it's in fact goods, as I'll explain in a moment. And so 6 of the bodies, those in Part 1, Mauritius Examination Syndicate and Mauritius Broadcasting Corporation. You can see the Examination Syndicate is on page 2763, and the Broadcasting Corporation is on page 2764. So the seven bodies that appear on page 2673, the ones in Part 1, Part 3, and Part 4, the types of contract there are subsets of the types of contract which you find in the schedule to the Act. Now, ICAC, the Independent Commission Against Corruption, if you see on page 2673, that is an exemption in respect of all contracts. If you go back to page 2762, you'll see the type of contract in the schedule there is also all contracts, because it is a parastatal body. Now, on the Supreme Court's approach, one is left with a nonsense. Section 3.2 of the Act, as I've shown you, provided that the Act did not apply to an exempt organisation, which was a public body exempted from the Act. The relevant regulations then defined an exempt organisation as a public body excluded from the Act in relation to contracts referred to in the first schedule to the regulations, but which regulations, according to the Supreme Court, then entirely annihilate the exemption. And that is the question that arises. Is the exemption provided by the Act and the regulations annihilated by a saving or interpretation provision? Now, it's fair to say that the STC plainly and correctly feels uncomfortable with the argument as found by the Supreme Court. Before the arbitrator, as he noted, it was unclear whether the STC was even running the point at all based upon Regulation 2A. And the position was put clearly in writing before the Supreme Court, where it abandoned the point. And you can see that at 2582 of the bundle. Where in their reply submissions at paragraph 65, STC said, you see in the second part of that sentence, STC no longer pursues any argument based on Regulation 2A of the Public Procurement Regulations 2008, no doubt recognizing that the point was nonsensical. However, it now seeks to resolve from that position, as it did orally before the Supreme Court, and to argue before you that firstly, the Supreme Court did not really mean what it said in terms of annihilation, and secondly, what it meant, and in any event what STC argues, is that the effect of the exemption was not to apply to all contracts of the type defined, but only to contracts of such type as were not major contracts. In other words, although the exemption on its face is in respect of particular types of contract, they now say it's only an exemption for those types of contracts which are not major contracts. And so the issues on under the PPA are, firstly, is the COA a contract of the type referred to in the first schedule to the regulations, so that the STC is excluded from the application of the Act in relation to it? And secondly, is such exclusion from the application of the Act provided by Section 3.2 annihilated by Regulation 2A, which introduced the exemption per the Supreme Court, or annihilated in respect of major contracts of that type per STC in its current argument? Now, before considering these points further, I'll introduce you to some further provisions of the PPA and also to explain how it evolved, which is helpful in understanding the construction issues. Now, you have already seen that Section 3 sets out the application of the Act. It's now necessary to see how the matter evolved. I showed you Section 3.2 as it stood at the date of entry into the contract. Now, if you could kindly turn in the main bundle to page 2602, you will see that the Act as it stood when it was drafted at 3.2, that the Act applied to any other procurement, that's other than procurement in 3.1, which we're not concerned with, effected by a public body. As you'll remember, the amendment changes this in that it then says other than an exempt organisation. And that, I've shown you, came in the Finance Act, Miscellaneous Provisions Act, or precisely what it's called, I can't recall, in 2009. Now, I've already shown you what is meant by procurement, and in this document, one sees that at 2601. But then the important point to note now is the definition of public body as it stood at that stage. This gets amended, but you have to, in order to understand what was going on, you have to see how it stood. So if you see at the bottom of page 2601, public body means any ministry or other agency of the government. B includes, and you can see it included, a local authority, a parastatal body, and such other bodies specified in the schedule, but does not include an exempt organisation. Now, the definition of exempt organisation I've shown you, but it's difficult to keep these things in one's mind. So if you turn back to 2600, you see, remind you, this didn't change. It's a body which is by regulations excluded from the application of the Act. So as things stood, this is really quite critical to understand, the combined effect of section 3.2 and the definition of exempt organisation was that the Act did not apply to a body which by regulations was excluded from the application of the Act. Now, just stopping there for a moment, you can see immediately a potential tension in that the Act at that stage excluded exempt organisations from being public bodies. But later, in the middle of 2009, it was decided rather than exempting public bodies as a whole, in respect of every type of contract, it would only exempt them for some. And I'm going to show you in a moment, the regulations which were introduced in 2008 originally worked on the basis that you would have an exemption for a public body which would be exempt for everything. And the public body that was originally exempt was our old friend ICAC. Now, the risk that because of this change in approach was that if only certain contracts of a public body were intended to be excluded, and you said so, there was a risk that the public body, because of the definition of exempt organisation, would become exempt as a whole. At least that would be an argument. And we'll come back to see how that evolved. But before we move on, it's important to also see the very extended definition of goods that the Act provides. And you'll see that at page 2600, so that the Act was, it adopts a very broad definition. You can see goods means objects of every kind and description, including commodities, raw materials, manufactured products and equipment, industrial plant, objects in solid, liquid or gaseous form, electricity, as well as services incidental to the supply of the goods, such as freight and insurance. Now, what is important, again, to get in mind from the outset, is that Parliament here, here we're looking at the scope of the application of the Act, adopted a very, very broad definition. And within the definition of goods, it also captured services incidental to the supply of goods, such as freight and insurance. So in other words, a freight contract or a contract of carriage was caught within the definition of goods, and it's perfectly plain that a freestanding contract of affreightment is caught within the definition of goods. And indeed, that is what the Supreme Court in this case said. You'll see that in the judgment in the bundle at page 228 to 9. And won't read it out. But that's where the at page 228, the Supreme Court analyzes, you can see, the definition of goods and freight. And on page 229, after line 10, they explain why the subject matter of the COA is in respect of freight as a service incidental to the supply of petroleum products, therefore falls directly and squarely within the definition of goods. As a result, goods would, for the purposes of column 2 of the schedule to the PPA, extend and apply in the present matter to a contract for the acquisition of freight which exceeds 100 million rupees, and that brought the COA within the ambit of the PPA. Now, what's important to understand is that the Parliament's approach to this, therefore, was A, to extend the definition of goods to cover things such as freight, but also was looking at a contract for freight, which, if it is incidental to the supply of goods, would be covered. Equally, a contract for insurance and so on. Now, the definition of works at page 2602 is also very extensive. And it'll become, you'll understand, I'll come back to in a moment why why that may or may not be important, but reliance is placed upon the difference between works and civil engineering works in the schedule, and I'll come back to that in a moment. Consultancy services are defined on page 2600, and again, it's just important to note those are services of an intellectual and advisory nature, not incidental to the supply of goods or to the execution of works. And then other services are defined on page 2601, and they mean any services other than consultancy services or services incidental to the supply of goods or execution of works. Now, the important point to note is that because of the extended definition of goods and works, a contract, for instance, of freight is a type of contract caught because that is treated as goods. It's not treated as other services because services incidental to the supply of goods or execution of works are not other services. Now, pausing there for a moment, we're going to see how the Act was amended and the regulations changed. But as things stood in January 2008, the contract of affreightment would have been subject to the PPA because it was a contract by a public body in respect of services, namely freight, incidental to the supply of goods. And that's what the Supreme Court said, and we agree. Now, just before we go on to the amendments, the effect of the Act applying, just so, and this is relevant when you come to consider the public policy element. A public body is subject to various requirements, and perhaps the simplest way of looking at this, rather than spending a lot of time, is to go back to page 2597, and just so you can see the index to the Act. No doubt at your leisure you can look through the provisions if you feel so inclined. It's probably quite a good cure for insomnia. The at page 2597, you'll see the scheme of the Act, and you'll see that there's a procurement policy office prescribed by Part 2, but Part 4 deals with procurement methods, Part 5, the bidding process, Part 6, challenges and appeal, and Part 7, procurement contracts. Now, what is important and is lost sight of very often in the arguments being made by STC is that the Act applies to all contracts, both, as it were, major and minor. The only distinction, and this is particularly important by the date of the COA, is that for major contracts, the Parliament have basically prescribed an additional form of oversight. Now, in the Act as it originally stood, so at page 2616, for instance, you will see that Parliament drew a distinction at section 26 between procurement contracts and other contracts in respect of certain provisions. But section 26 was amended by the time of the COA, so that in fact the provisions as a whole apply. The difference between a major contract and an other contract was that for major contracts, sorry, let me take it in stages. For contracts generally, there is a procurement process whereby bids and so on have to be evaluated by a bid committee established by the public body. Where you have a major contract, there's an additional level of oversight, which is that instead of it being simply the public body that establishes the oversight committee, the Central Procurement Board, which you see back at 2597, is established. It had a role in overseeing the contracts. So in other words, for very large or larger contracts, there is this additional oversight. And section 14 provided in terms that for major contracts, you can see this at 2608 to 2609, at 2609 subsection 3 of 14, the board had to approve the award of every major contract, and 5, no person shall sign a major contract unless the award has been approved by the board. As I say, once you understand how it works, this is what it was doing, was applying an additional level of oversight. Now, so the important thing to note at this stage, whether a potential contract is a major contract or not, doesn't determine whether the Act applies to it. And indeed, many, if not all, of the mandatory provisions of the Act, other than those that specifically only apply to major contracts, apply irrespective. And for instance, sections 37, 39, 40 are good examples. Now, that brings one to the definition of major contract. And just because we're in this volume, if you go to page 2601, and for your note, alternatively, page 15 in the supplementary bundle, you'll find the definition of major contract, a contract for the procurement of goods or services, or the execution of works, to which a public body is or proposes to be a party, and the estimate of the fair and reasonable value of which exceeds the prescribed amount. And you can see one could imagine cases where there's a dispute about that. Prescribed amount is an important definition on this same page, because you can see it means the amount specified in column 3 of the schedule corresponding to the public body specified in column 1 in relation to the type of contract specified in column 2 of that schedule. Now, the reason I read that out and stress it, what it shows is that the draftsman is fully aware of the three concepts. You've got public body, type of contract, and amount specified in column 3. Now, the schedule, as it originally stood, as it got amended, as I've shown you this morning, is to be found at page 2633. So this is the schedule in when the Act was passed. And you'll see, just casting your eye down, that the public bodies were not identical, in that the parastatals are not specifically identified. And you'll also see that the types of contract, I think, that are no different, but you'll see that the amounts, the prescribed amounts, differed at this stage for different types of contracts. So you see under part 3, for the first one, goods, civil engineering and capital goods, 10 million, consultancy services, 5 million, and so on. And then on page 2634, where the STC and the Central Electricity Board and the Mauritian Broadcasting Corporation appeared, you had different limits for different types of contract. Whereas, and then you also had cases where it was all contracts, no distinction between different types. Now, you will recall from what I've shown you, or I hope you will, that the Act applied to procurement contracts in respect of goods, works, consultancy services, or other services. Now, what we were just looking at, page 2633, and the schedule as it later gets amended, uses exactly the same words, namely goods, consultancy services, and other services, but with one area where it's different. It refers to civil engineering works and capital goods. Now, in view of the broad definition of works, which I showed you, which if you perhaps want to just cast your eye back to it, at page 2602, it is difficult to see that civil engineering works and works would not be entirely coextensive. But even if that is not right, and as I say, it's difficult to see how what civil engineering works would be referring to which were not works, it's plain that Parliament was using that to refer to the type of works that it anticipated potentially would be entered into. Now, just a couple of other points to note before we move on to the regulations. We don't need to turn it up. Section 61 provided a power to make regulations, as you would expect. The relevant minister had the power to make regulations. Section 14, I've already shown you, in the position of the Central Procurement Board. Section 25 dealt with direct procurement. Direct procurement was permitted in certain circumstances, and where direct procurement is permitted, Section 14 does not apply. And we know that from an amendment that was also made to the Act in 2009 it's at Section 14 sub 6, which for your note you'll find at page 32 of the supplementary bundle. Now, I draw attention to that because, again, when you come to consider the public policy arguments and the argument that the PPA embodies public policy, and any breach, for instance, of Section 14 is some breach of fundamental public policy, consider the case of direct procurement. suppose a view had been taken that a contract, that the public body was entitled to use the direct procurement method, and there was an issue as to whether or not, on the facts, that was right. How you'll want to consider, do the public policy arguments fit with that? Now, within the statute, there are a number of provisions which impose duties on the board or the public body, in other words, to follow the provisions of the Act. But the Act does not state, so I can't show you the provision because it doesn't state it. The Act doesn't state that where the board or the public body has acted in breach of duty, any contract is void. Now, there are also detailed provisions about what are to be included in the contract. You'll see that at sections 46 to 47, page 60 of the supplementary bundle. And again, you'll want to consider on the STC's case, what is the effect if there is a breach of that mandatory provision? Now, there are also then detailed provisions in sections 43 to 45 concerning rights to seek review where matters have not arguably followed the provisions of the Act. And in the main bundle, you'll see page 2623, and in the supplementary bundle at page 54, that you'll see at section 43.1, a bidder who claims to have suffered loss or injury due to a breach of duty imposed on a public body or the board by this Act may challenge the procurement proceedings at any time before the entry into force of the procurement contract. In other words, the mere fact that there is a breach of duty can't itself ipso facto render the contract void, because the Act itself contemplates the entry into force of the procurement contract. And bidder, just to make it clear, bidder is very broadly defined, and it means so on page 2600, it means a participant or potential participant in procurement proceedings. In other words, somebody who hasn't participated but potentially would have done is treated as a bidder. And similar provisions showing that the Act contemplates a contract coming into force, notwithstanding breach of the terms. You see at 45.1c on page 2624, which talks about before or after the entry into force of a procurement contract, and similarly subparagraph 10, which gives the review panel a power to, amongst other things, annul a contract or an unauthorized act at 10b, and at 10d recommend payment of reasonable costs to a complainant where a legally binding contract has been awarded, which should have been awarded to the applicant. So the whole scheme of there's nothing in the Act to suggest a contract is void if the PPA is not followed. Quite the opposite. The scheme of the Act proceeds on the premise that essentially the rules of contract apply. Now, the regulations, if you get what we need first, we need to look at how the regulations evolved. So if you go to page 2636, these are the 2008 regulations, which came into force at, I think, more or less the same time that the Act came into force. In other words, in January of 2008. Yeah, the 14th of January 2008. And the relevant point to grasp at this stage, at 2636, you'll see exempt organization means a public body which is as specified in the first schedule, which is excluded from the application of the Act. Now, you've already seen, sorry, this gets confusing because of these definitions, but you've seen this is what gets changed, this definition. But as things, as things stood at that stage, the only body that was excluded, you'll see at page 2665. So 2636 says a public body excluded from the application of the Act. 2665, exempt organisation, independent commission against corruption. So what Parliament intended was that ICAC would be totally excluded. And it's in this context that it's important to note the definition of parastatal bodies. So if you go back to 2636, a parastatal body means an organisation established under an enactment, whether body corporate or not, which depends wholly or partly on government funding. So ICAC is such a body, and when we see the amended schedule, I showed you where that refers to parastatals. That's how that would encompass it. Now, the other thing to note is that the draftsman of these regulations is fully aware and understands the concept of major contracts as a defined term. For instance, if you go to 2637, section regulation 4 deals with bid evaluation procedures for major contracts. Page 2639, section regulation 7, again, bid evaluation procedures for contracts other than major contracts. So he's fully aware of how that works. Now, the other point I'd like to draw your attention to in the regulations is the next one is page 2655 and 48.7, which again you can see refers to applications for review from an unsatisfied bidder after the entry into force of a procurement contract. Time limits for that, totally inconsistent with the idea that a breach of the PPA necessarily renders a contract void. At 2661 is regulation 67, which is that the regulations specifically provide for arbitration. So the parties to a procurement contract may agree in the procurement contract or by a separate agreement to submit any dispute arising out, and obviously two words have been missed out, of or under the procurement contract for settlement by arbitration. Now that's important when you come to consider my next submission, which is Parliament specifically contemplated that any disputes relating to a procurement contract could be settled by arbitration. That would include disputes about whether or not the provisions of the PPA had been followed. Yet STC's argument is that this is the question of whether there's a breach is a fundamental matter of Mauritian public policy, so that effectively a determination by an arbitrator can't be final and binding. In our submission, that is again inconsistent with this scheme. Now, with that then brings us to the 2009 regulation, which we see at page 2672, or it's the amendment regulation which amended the 2008 regulation, which we've looked at. And before considering this, or it's necessary to keep in mind the definition of public body in section 2 of the Act and the scope of the Act as it then stood in section 3.2. So this gets changed a month later, but at this stage, the Act only applied to procurement by a public body. A public body did not include an exempt organisation. An exempt organisation was one by regulations excluded from the application of the Act. So the 2009 regulation, which we have open, amended the definition of exempt organisation. And now the intent rather than exempting a public body in respect of everything, was to exempt a body in respect of types of contract rather than in respect of the organization as a whole. Now, I've already shown you that from the beginning, ICAC was totally exempt under the 2008 regulations. So how were you going to ensure that ICAC was exempt? Well, ICAC, in exactly the same way, the answer was at page 2673, it is exempt in respect of all contracts. Now, the difficulty with this mode of providing for an exempt organization was that it was at least arguable that a public body which was exempt in respect of certain types of contracts would cease to be a public body for the purposes of the Act as it then stood. So the purpose of Regulation 2A was to ensure that such a public body would continue to be subject to the Act as a public body. In other words, it was saving the Act and ensuring that such a public body would continue to be a public body in respect of contracts in Schedule 2 to the Act. But obviously, it was not intending to cut down on the primary purpose of the regulation, which was to exempt the contracts which are set out in the schedule to the regulation. And indeed, so to find renders the regulation totally meaningless. Now, what you will note is that the draftsman referred to contracts of a specified type. He did not refer to procurement contracts of or above the prescribed amount, nor did he refer to major contracts or anything of that sort. Now, the purpose of the saving was to ensure that the application of the Act in its entirety to all contracts other than those in respect of which an exemption was provided. Now, if you look at page 2673 and we take the first four bodies, there plainly was not intended to be any exemption for instance, civil engineering works, consultancy services, or other services, unless they were within the defined types. Similarly, for the Mauritius Examination Syndicate and the Mauritian Broadcasting Syndicate. So what the Act did was make it clear, for instance, the State Trading Corporation remained subject to the Act in respect of all procurement contracts, except for those which were the subject of this specific exemption. Now, ICAC provides a useful illustration. As I've explained, it's a parastatal. It's a public body within the definition of the Act. It had previously been entirely excluded. The amendment was plainly not intended to affect its status. If you treat Regulation 2A as annihilating the effect of the exemption, then you end up in a position where, firstly, ICAC was wholly exempt under the 2008 regulations. The 2009 regulation says it's exempt in respect of all contracts, but then it becomes subject to the Act in respect of all contracts because, as you'll remember, at page 2762, column 2, in respect of parastatals, refers to all contracts. In other words, a complete and utter nonsense. Now, the point to bear in mind, as I've already made clear, is at this stage the Act had not been amended. The draftsman, no doubt, didn't know whether the Act would be amended or not. It obviously depend on parliamentary time. Now, at 2674, we have the Finance Miscellaneous Provisions Act, which, as I've said, amended a number of pieces of legislation. And item 35 at page 2738 is, well, section 35, amended the Act. And the amendments that we're concerned with are in 35A, B, and A and B in particular. And what you can see, the definition of public body was amended by deleting the words semicolon but and replacing them by a semicolon, and by repealing paragraph C. And so just so one can understand that, if you flick back for a moment, notionally, to page 2602, what that meant was they were taking out of the definition of public body the word but on page 262, and then C, does not include any exempt organization. And the relevance of that was that to stop an exempt organization ceasing to be a public body, and then if we go back to 2738, they then repealed at B subsection 3.2 by adding in at the end of 3.2 the words other than an exempt organization. In other words, that changed section 3.2 to the form that I showed you. And here you see the parliamentary draftsman enacting an amendment which made clear that a public body is excluded from the application of the Act in relation to contracts of the type specified in the schedule. And at the same time, he then provided the revised at 2762 schedule to the PPA itself. So I see the time, that might be a convenient moment.
Yes, thank you very much. All you need to do is mute your microphone and switch off the video. Thank you very much. Mr. Howard, are you ready to resume?
Certainly, thank you, my lord.
Thank you very much.
So turning to the issues that arise, what type of contracts are referred to in the first schedule? Now, to the regulation, and if one has 2673 open, 2673 open, that makes the point easier to address. In considering that, as I say, it is useful to look at consider the role of the various bodies, and particularly the State Trading Corporation, which is responsible for sourcing and importation of essential strategic commodities to cater for the needs of the domestic market. In our submission, it is obvious that the exclusion of a particular type of contracts, which is referred to, is concerned with a contract in respect of goods which are purchased for resale, contracts in respect of services incidental to the purchase of such goods, and contracts in respect or incidental to the distribution of such goods. Now, there's no question that the contract of affreightment is a contract for the provision of freight services, although the nature of the contract was that my clients had to go out and commission the building of the vessel and so on. In simple terms, it's a contract for the carriage of oil imported by STC for resale in Mauritius. Now, I've already shown you that the definition of goods in the PPA is very broad, and I've shown you that the Supreme Court correctly considered that a contract for freight fell within that definition. And so there's no question that the COA can properly be described as a contract for the provision of freight services incidental to the supply of goods, or, well, that's sufficient. Now, under the regulation, both the contract for the primary goods themselves, namely the petroleum products, and the freight services incidental to the supply or the distribution of such goods fall within the words of the exemption. Now, there's no dispute that the petroleum products that are purchased by STC are purchased for resale. Indeed, that's the whole function of STC. And the contract of affreightment falls within the first part of the exemption, goods purchased for resale, because you have to apply the extended definition of goods in the Act. Now, the argument that's made against that is to say, well, the freight is not purchased for resale. Now, in our submission, that's actually a rather meaningless point, particularly where what the STC does is entirely pass on the freight costs. But it would be totally nonsensical to talk about a freight being purchased for resale. And the parliamentary draftsman in our submission plainly intended to cover freight and insurance, just as he did in the original definition. But that doesn't really matter. We say that's actually plainly correct. But you're then concerned with, well, what about the words following the comma, including services incidental to the purchase or distribution of such goods? Now, again, there's no question that the COA is a contract for services incidental to the purchase or distribution of goods. The debate comes down at this level to an argument that the STC now runs, contrary to what you saw in its public stance when seeking replacement contracts of affreightment, that what they say is, oh, well, the only contract of affreightment that is covered is one which is allied to in the same document as a contract for the purchase of goods. Now, in the context of a body like the STC, responsible for importing strategic commodities, this is obviously nonsensical. It's plain that what Parliament intends is to exclude the STC and these other bodies from both contracts to purchase and service contracts which are incidental to the purchase or distribution of such goods. And it certainly includes freight and insurance. And in fact, because of the reference to distribution in the schedule, it is probably wider. Now, look at the Mauritian Examination Board. Their type of contract is goods purchased, including services relating to or for the purpose of the holding of examinations. In our submission, it's utterly obvious that what is the type of contract, there are two types. There's goods purchased relating to the purpose of the holding of exams, and services relating to the purpose of holding of exams. And both are intended to be exempt. Now, STC's case essentially comes down to saying it all has to be within one contract. Now, firstly, there is nothing in the wording of the exemption to suggest that the exemption only applies where the purchased primary goods and the services all form part of a single contract. And it's most unlikely, for instance, that the STC would enter purchase contracts which also entailed services relating to the purchase and distribution of goods being purchased. There's no reason why a service contract incidental to the purchase or distribution should be excluded from the Act when part of the purchase contract, but not when it's a standalone. And indeed, we gave, and I won't go through it, the example of the difference between FOB and CIF contracts, the idea that Parliament intends that where you purchase the goods on a CIF basis, everything is excluded, but where you do it FOB and you're responsible for the freight contract is not excluded. STC's construction makes the application of the PPA turn on an issue which is totally trivial and immaterial to its purpose. The STC accepts, for instance, that Parliament has chosen to apply the PPA to contracts for the supply of goods. Equally, that the PPA applies, by virtue of the words as well as in the definition of goods, to separate contracts for freight services. It accepts that Parliament has exempted the STC from compliance with the PPA where it executes a contract for the purchase of goods for resale. Also, that Parliament has exempted the STC from compliance with the PPA where it executes a single contract with two elements, namely purchase and the ancillary service element. But they say, where the STC executes separate contracts dealing with those two elements, then the contract for the purchase of goods for resale is exempt from PPA compliance, but the separate freight contract is not. And you will have noted in my learned friend's submissions that the furthest they go is to say that this is not necessarily an anomalous result. That's paragraph 91.4. Not necessarily an anomalous result. Hardly a very convincing point in support. Well, it actually plainly is anomalous, and it is not what Parliament could have intended. Now, so in our submission, as the arbitrator held, the COA plainly was a contract which was exempt, as everybody thought at the time, and that was entirely right. So, as I've explained, the Supreme Court didn't express a view on that because they go straight to Regulation 2A. Now, what did the Supreme Court find about Regulation 2A? My learned friends seek to say they didn't find, in effect, that Regulation 2A annihilated the exemption. I'm afraid that argument is simply not sustainable. If you could turn to page 225, you will see that the Supreme Court expressed themselves in trenchant and unequivocal terms. So they said on page 225, what Regulation 2A, just below the quote, is stating, plainly stating, is that the PP regulations, which provide for exempt organizations, cannot operate to exclude the application of the PPA in respect of a procurement contract specified in column 2 of the schedule. In other words, there can be no exemption from the procurement process of the PPA by virtue of the regulations if the COA is a type of contract which falls within the scope of the application of column 2. The COA then would then be subject to the application of the PPA in the procurement process. And they make exactly the same point. I won't read it out because of the shortness of time. On page 226, in the sentence beginning, the paragraph beginning the plain and ordinary wording at and at the rest of that page, note paragraph 3 on that page, and at page 227, both the first paragraph and the last paragraph, and page 233, paragraph beginning, that argument is misconceived. And the next paragraph, and 235 couldn't really be put much more clearly. In the second sentence, the plain meaning and force of the wording used in Regulation 2A annihilate the application of any exemption under the regulations in relation to any of the contracts referred to in the first schedule to the regulations where the intended contract by the public body is one which falls within the specifications set out in column 2 of the schedule. The STC could not therefore, by virtue of Regulation 2A, qualify as an exempt organisation under PPR Regulation 209 in respect to the COA. Now, so in other words, what the Supreme Court found, there was no exemption whatsoever. There cannot be any, is the words they use, and annihilate, for any contract of a type within Schedule 2. This was notwithstanding the fact that the types of contract within the schedule to the regulation were subsets of the contracts within column 2 of the schedule or entirely overlapped. So in other words, this was total nonsense. So something has plainly gone wrong in the Supreme Court's reasoning. It went wrong at every stage, but in particular, it went wrong that it failed to consider and properly construe Section 3.2. And it's interesting that on page 235, after having said what the regulations does, it refers to section 3.2, but it fails to ask itself, it actually quotes it. Section 3.2 specifically provides this act shall apply to any other procurement effected by a public body other than an exempt organisation. That, of course, is added a month after by Parliament, after the initial regulation. And the Supreme Court simply fails to ask itself, well, what was Parliament intending? And it fails to consider the point that the Act applies to procurement by a public body other than an exempt organisation. An exempt organisation is defined by the Act, then by the regulations. So section 3.2 means that the Act applies to procurement by a public body other than the public bodies excluded from the application of the Act in relation to contracts referred to in the first schedule. Or to put it perhaps in more simple English, the effect of section 3.2 is to exclude STC from the application of the Act in relation to contracts of the type referred to in the schedule. And the Supreme Court's construction simply turns section 3.2 on its head. It actually means there are no exempt organisations. Now, I've explained how it evolved. I think I probably need to move on because of the shortness of time. And just to consider briefly...
Mr. Howard, Lord Leggett has a question for you.
Yes, of course.
I just want to make sure I've understood what you say the effect of the saving provision is, Mr. Howard, the new regulation 2A. If I've understood it right, I'm looking at page 2672. If I've understood you right, then what you say that the intention was, and it would have been made clearer if it had said, when it referred to contracts specified in column 2 of the schedule to the Act, that they meant contracts specified in column 2 to the schedule insofar as they're not of a type specified in the first schedule to the regulations. Is that right?
Yeah,
that's what they intended to say.
That's what it is intended to mean. I mean, you can use other drafting techniques other than the contracts referred to in the schedule to this regulation. And in our submission, that's what it plainly means. If you adopt the Supreme Court's approach, you then are cutting down the whole thing, making it all into a nonsense. My learned friend's argument is what is actually intended is something completely different. And so he says, oh no, well, what it was intended to do by reference to column 2 of the schedule to the Act was also to refer to schedule 3. So now that's not what it says.
Column 3, or sorry, did you mean column 3?
Yes, you must mean column 3.
Yes, I meant column 3, I beg your pardon.
Yeah.
My learned friend's argument is that what you should read it as, which is specified in column 2 and column 3. Well, now that would actually be a rather cockeyed way of doing it. It's not what it says, but it would also, I mean, the very simple point that they make is if Parliament had intended to say you are going to be exempt, save in relation to major contracts, you wouldn't need 2A at all. You would just have defined exempt organisation as saying in relation to contracts referred to in the first schedule, save insofar as they are major contracts, a concept with which the legislature was entirely familiar.
Thank you.
And perhaps just to complete on that point, first, the wording of the regulation, this is a savings provision nothing in these regulations shall be construed as, or an interpretation provision. It's not intended to be, as it were, a scoping provision. Had it been intended to carve out major contracts, then that would have been simple to say. Apart from the fact that column 3 is not mentioned, a further problem is that the schedule to the 2009 regulations refers to type of contract, and regulation 2A refers to column 2, which identifies the type of contract. So what is clear is that certain types of contract are intended to be excluded. Those types of contract are all subcategories of what is in Schedule 2. And so far as you are saving the types of contract in Schedule 2, you're plainly intending to save them in respect of all provisions of the Act, but not those that fall within
Again, Mr. Hard, when you refer to Schedule 2, you mean column 2, is that right?
I mean column 2 of the, I beg your pardon, it's confusing. Column 2 of the schedule to the Act. One's got to keep in mind there's the schedule to the Act and the first schedule to the regulations. I apologize. And the schedule to the Act has 3 columns, which the draftsman was very familiar with. Now, I think because of the time, I probably need to move on. But on this point, the ICAC point would be particularly strange in that the effect of the STC's submission is that ICAC, which had always been exempt, no basis for thinking anybody intended to change it, on the argument of the Supreme Court, they entirely lost their exemption. On the argument, and the reason for that is the Supreme Court would look at page 2762 and say all contracts of parastatal bodies are caught, so ICAC had no exemption. And on STC's case, they had no exemption in respect of contracts above 15 million rupees. Now, there's absolutely no basis to think that that is what Parliament intended. And the other point is that STC's and the Supreme Court's arguments are entirely inconsistent with Section 3.2. And I do come back to that. That is ultimately the Act and the operative provision that you've got to construe. It also makes no sense that the PPA was that an exemption is being introduced which exempts the STC and these other bodies from contracts, as it were, minor contracts, but applies the PPA to major contracts. The PPA, and I think this is part of the misunderstanding that one needs to put out of one's mind, applies to all contracts. Now one has, if Parliament had said, well, we're going to exempt you from the requirements, why would it exempt you for some contracts of a particular type and not others? And in our submission, there's absolutely no rationale to that. And it's also interesting to note, if you look back at the amended Act, and the fact is that Parliament has continued to add bodies to the bodies and types of contract to the regulations. So if you go to supplementary bundle page 117, you'll see, well, perhaps for developing that point, in considering this point, you have to consider, for instance, the Mauritius Broadcasting Corporation, who got an exemption for the purchase of films or acquisition of transmission rights for public broadcasting. Did Parliament, on the STC's now argument, intend to provide a complete exemption for that type or only a limited one? But when you consider, for instance, page 118 and any public body, so this, it doesn't matter what type of public body you are exempt for procurement of goods, works, consultancy services, or other services funded by at least 50% of the estimated project value from grant or concessional financing as the minister may approve from a foreign state where the condition imposed by that state specifies the supplier of goods and so on shall be from that state. That's perfectly clear. This has got nothing to do with contract values or a ceiling. It's just looking at a particular type of contract where 50% is provided by finance from a foreign state and so on. In other words, the whole scheme of this is that these are bodies who are exempt from the PPA as a whole. Now, in our submission, the conclusion is that the Supreme Court went off completely on a wrong tack, and the COA, the contract of affrayment, was exempt. Now, and the arbitrator was entirely correct. Perhaps I want to just show you one other thing, notwithstanding the shortness of time, which is what the Supreme Court said about the arbitrator, because it actually shows the misunderstanding that the Supreme Court operated under. Yes, if you go to page 231 in the bundle, you'll see that the Supreme Court referred to the arbitrator's finding at paragraph 159 to 161 that the regulation 2A didn't apply. And what is interesting is it actually shows how the Supreme Court got everything the wrong way round. Because what the arbitrator, the premise of on which the arbitrator was looking at things was that the contract of affrayment fell within the exclusion. And so what he was considering was, well, is it nevertheless capable of being a contract which is still covered by Regulation 2A? And the reason he was considering other services is that it was only other services which he could contemplate, if it was a contract for other services, that could fall within the ambit of Regulation 2A, in other words, hadn't been excluded. And because the Supreme Court failed to consider the scope of the exclusion, they failed to understand the logic of what the arbitrator was saying. And as I say, if one approaches this properly, you consider section 3.2, then you consider the schedule to the Act and construe that. Once you have recognized that, sorry, the first schedule to the regulation, once you've recognized the COA falls within the type of contract there described, then when you come to Regulation 2A, the answer in fact becomes, I would suggest, relatively obvious. Now, that is the, as it were, the merits point, which we say, in fact, the Supreme Court should never have got to. Now, it's taken me quite a long time, so I'll have to deal with this point, which is a point of law, which is of, as it were, of importance across the arbitration world, which is how the court should intervene. Now, in simple terms, the Supreme Court and the STC fall into error in that they fail to recognize the importance of the following points. Firstly, the question of statutory interpretation of the PPA. So here, if one asks, well, what is it? What are we talking about here? The meaning of section 3.2, the question whether the STC was an exempt organization and so excluded from the application of the Act in relation to contracts referred to in the schedule, and the effect on such conclusion of Regulation 2A, were all matters that fell within the jurisdiction of the arbitrator. That's the first point. The second point is Parliament had specifically permitted such questions to be arbitrated. The third point is Parliament had provided that international arbitration awards should not be susceptible to challenge or appeal on questions of law. They should be final and binding. Fourthly, the court's scope for intervention is limited to situations where the award is in conflict with the public policy of Mauritius. Fifthly, the fact that an issue of illegality, including a question of the interpretation of the PPA and the regulations, was raised in an arbitration, does not entitle a court to conduct a de novo review. Indeed, such an approach entirely undermines the policy of the International Arbitration Act. The starting point before the arbitrator was the contract illegal? The starting point for the court, where the arbitrator has held the contract was not illegal, is whether his award is contrary to public policy. That's the question. You have to distinguish the underlying issue which was before the arbitrator with the award. For instance, it may be alleged that a contract was to bribe, something which we all recognize would be contrary to public policy. A tribunal finds, no, it wasn't. It was a legitimate contract for services. Now, the fact that that was an issue and the issue would go to questions of public policy doesn't mean that a review court can say, right, I'm going to look at all of this again and decide whether in fact the contract was for bribery. Now, STCs start from the proposition that the PPA reflected the public policy of Mauritius in respect of the award of major public procurement contracts. Now, they choose to put it like that, but of course, that is not a correct statement of the position. The PPA reflects the public policy of Mauritius on everything it covered. So any award, if you follow the logic of their approach, dealing with questions of the scope or breach of the PPA would be susceptible to review because it involves a question of public policy, because the statute reflects public policy. But of course, any statute reflects the public policy of a state. That is why it is passed. So simply asserting that the PPA reflects the public policy of Mauritius with regard to the public procurement process to be adopted for the award of a major or minor contract doesn't matter, doesn't advance matters. Indeed, it leads to the extreme conclusion that an issue concerning the interpretation of a statute is incapable of being arbitrated, a position which you will note the STC did adopt in relation to the PPA issues in dispute, but which it has now abandoned. And so the critical question for you is whether an award which determines that a contract was in accordance with the legislation and not in breach of it, that award being within the tribunal's jurisdiction, is that a decision that the court can itself review to decide whether that question was correctly answered so that it can then go on to decide whether the award is in conflict with the public policy of Mauritius. And the issue, therefore, is whether the court was entitled to review the point of statutory interpretation which the arbitrator had determined in Betamax's favour. And it is common ground that that question of statutory interpretation is separate from the question of whether the public policy of Mauritius required the tribunal or the court on a review of the award to refuse to enforce the contract of affreightment. Now, the starting point is the scheme of the International Arbitration Act. As we've explained, it is modelled on the UNCITRAL model law. It is based upon the well-known principle of non-intervention, and we've referred you to the Travaux, and I won't take up time, but it is important to note that one of the policies here is to attract foreign parties to arbitrate in Mauritius. And in our submission, that policy would be undermined if one adopts the approach that the Supreme Court adopted here, particularly where, as you'll see from the judgment, the basis upon which the Supreme Court found that it was entitled to intervene essentially was that this was a major contract which involved a large expenditure of money by the government of Mauritius, and that of itself, as it were, raised public policy issues. Now, in fact, that's a misconception in that the way in which STC operates is it actually passes all the costs on to the oil majors, who pass the costs on to the public. That's just as a by the by. But none of that in our submission is the right approach and undermines the approach. And it's also important, as we pointed out, to understand your role, and I say the role of the board, in that the Privy Council has deliberately been given a key role under the statute, and that is in order to ensure that Mauritius is in line with the approach in international arbitration. Now, I've already explained, and you won't be surprised, that the Act at section 36(7) provides that an award is final and binding, and only provides limited recourse against an award. Now, the issue that one needs to bear in mind is that before the arbitrator, STC had contended that the COA was illegal, and that, they said, went to jurisdiction. They don't pursue that anymore. But the arbitrator considered STC's case and rejected it. Now, there's no further factual evidence which is relied on, nor is it said anything was done which was procedurally unfair. So the question comes down to whether the public policy ground of challenge in section 39 entitled the Supreme Court to revisit and set aside a finding of an arbitrator acting within the scope of his jurisdiction, that the statute had not been breached and the contract was not unlawful. And we submit that the answer to that, when you properly consider the authorities, is plainly no. Now, the relevant cases which have had to consider this matter are the well-known cases in this jurisdiction of Westacre and Soleimani. And your lordships will recall that Soleimani involved some obiter dicta in the Court of Appeal by Lord Justice Waller, suggesting that a court where public policy issues were involved might have a basis for some sort of examination. I'll show it to you in a moment, but it was all very tentative, and it certainly wasn't a de novo review. But that view was firmly quashed in the Westacre case, where Lord Justice Waller was on the tribunal, but the majority firmly said they disagreed with his obiter dicta in the earlier case. And then there's been a more recent Court of Appeal decision which has endorsed what the Court of Appeal said in Westacre. Now, in this case, a lot has turned on the views of the Court of Appeal of Singapore, which was applying in a case called AJU, which was applying the dicta from Westacre. And because of the shortness of time, I'm not going to go through Westacre and Soleimani. I'm going to pick up the references by looking at the decision of the Court of Appeal in Singapore, which was what the Mauritian Supreme Court was purporting to follow, and to look at another decision in Singapore called Rockaby. So I hope your lordships will forgive me if that appears slightly compressed, but I've only got about 30 minutes in which to cover the topic. And so can I ask you to go, the other Court of Appeal case, of course, is Sinecure. Now, the AJU case provides, is at 3098. And the case concerned a dispute as to the validity of an agreement, which was referred to in the case as the concluding agreement, which was governed by Singapore law and under which the respondent was to terminate an arbitration upon fulfillment of certain conditions. And the respondent alleged that the concluding agreement was illegal because it was an agreement to stifle a prosecution in Thailand of forgery offences, which were non-compoundable and could not be compromised. And the concluding agreement was said, therefore, to be contrary to Thai and Singapore public policy. Now, the SIAC, Singapore International Arbitration Tribunal, rejected the respondent's argument, having heard the evidence and considered the terms of the contract. And the respondent applied to set aside the interim award in Singapore as the supervisory court on the grounds of public policy under an analogous provision to the one we're concerned with there, section 34(2)(b)(2). And what happened was the first instance judge revisited the tribunal's findings and held that the concluding agreement was an agreement that was illegal under both Singapore law and Thai law, and he set the interim award aside on grounds of public policy. Now, it was common ground before the Court of Appeal that the concluding agreement would be illegal and in conflict with public policy if it required the parties to stifle the prosecution of forgery charges. And you can see that at page 3112 at paragraph 19. Now, in the light of the tribunal's finding, if you go to 3114 at paragraph 3114 at paragraph 22, you can see that the court said, in the light of the tribunal's finding that the concluding agreement was valid and enforceable, public policy was prima facie not engaged for the obvious reason that there was, according to the tribunal, no illegality in either the terms or the performance of the agreement. Hence, the critical issue before the judge was whether the court, in dealing with an application to set aside an arbitral award founded on a contract which had been held by an arbitral tribunal to be valid and enforceable, could reopen the tribunal's findings of fact and or law and decide for itself whether the contract in question was illegal. And so that was the question. Now, the decision of the Court of Appeal was that the judge should not have reopened these findings and have decided the matter for himself. Now, if we go through the decision, you will see at paragraph 37, the court considers the scope of public policy. Don't think I need to detain you on that, but at page 3125, the Court of Appeal then considers the English authorities. So at 3125, they start with Westacre, and that runs through to 3129. Then they consider cases subsequent to Westacre. And at 3134, they consider the Court of Appeal in Westacre, and that is the well-known passage at 3134 of Lord Justice Mantell, in which he says why he disagreed with Lord Justice Waller's approach. And they get at page 3139 to seeing that there was a divergent approach in England between Westacre and Soleimani. Just stopping there for a moment, you'll remember that Soleimani was a case which concerned an arbitration which was held under the Beth Din, the Jewish Religious Court, where the arbitrator there had found that the contract was a contract to do something unlawful. It was a smuggling contract. It was to smuggle carpets out of Iran. But under Jewish law, the fact that you had a contract to do something illegal was neither here nor there. It didn't matter. And so it was a dispute between a father and son relating to the proceeds of the scheme. And so on the facts of Soleimani, you had something which was palpable illegality on its face, according to the findings of the arbitrator. What the arbitrator had done, though, was to say, well, notwithstanding that, this contract can be enforced. And when one refers to Soleimani, it's quite important to understand that's what the factual position was in that case. But at 3140, paragraph 60, the Court of Appeal in Singapore made it clear that they didn't agree with the approach taken in Soleimani by Lord Justice Waller and in Westacre. And in our view, it's the majority's approach in the latter case, that's Westacre endorsing Mr. Justice Coleman in Westacre, which is consonant with the legislative policy of giving primacy to the autonomy of arbitral proceedings and upholding the finality of arbitral awards. Now, the Supreme Court in this case seems not to have properly understood that was what the Court of Appeal was saying. Now, the critical paragraphs, though, which the parties have referred to here are paragraphs 62 and following. And essentially, it's 62 through to 71, which one needs to read. Now, what one needs to be careful in reading those paragraphs is not to take one paragraph in isolation and out of context, because if you do, it can be misleading. Now, what you will see from paragraph 62, this is a paragraph that both the Supreme Court and my learned friend place a lot of reliance on. You can see that the court said that, be that as it may, since the law applied by the tribunal was Singapore law, the question that arises is whether, if a Singapore court disagrees with the tribunal's finding that the concluding agreement is not illegal under Singapore law, the court's supervisory power extends to correcting the tribunal's decision on this issue of illegality. In our view, the answer to this question must be in the affirmative, as the court cannot abrogate its judicial power to the tribunal to decide what the public policy of Singapore is, and in turn, whether or not the concluding agreement is illegal. Illegality and public policy being, as pointed out above, mirror concepts, however eminent the tribunal's members may be. Accordingly, we agree with the judge the court is entitled to decide for itself whether the concluding agreement is illegal and to set aside the interim award if it is tainted with illegality, just as in Soleimani, the court refused to enforce the Beth Din's award as it was tainted with illegality. Now, what the court here is not saying, but this is how it is being construed by my learned friend and by the Supreme Court, it is not saying that where a finding on the merits has been made, for instance, on a question of whether a contract was illegal, it entitles you to intervene. Now, that becomes clear when you read the next paragraph. So, no, but before we get there, you can see what they referred to here was Soleimani as being the example. Soleimani, the whole point was, the arbitrator had held that the conduct was, or the contract was, to do something illegal, but he said it could still be enforced. Now, it's that question, having decided it was illegal, it was palpable illegality, it was tainted with illegality. It was a question of English public policy, whether that award, an award to enforce a palpably illegal contract, could be enforced. Now, that's what's important to see at 63, where they then go on to say this conclusion does not mean that in every case where illegality is invoked, the court is entitled to reopen the arbitral tribunal's finding that the underlying contract is not illegal. And then they go on to explain why that is so. And I won't read it out, but commend 63 to you. And then 64 makes, again, is echoing the Soleimani point. So at 64, they explain, in our view, this was not an appropriate case for the judge to reopen the finding that the concluding agreement was valid and enforceable. The tribunal did not ignore palpable and indisputable illegality, as the Beth Din did in Soleimani. And then if you would go to the end of the paragraph, where they say, in short, this case is not a Soleimani-type case involving an underlying contract clearly tainted by illegality, but a Westacre or OTV-type case, where the respective tribunals found that the underlying contract in question did not involve the giving of bribes to, but merely the lobbying of government officials, which lobbying was not contrary to English public policy. And so they say at 65, the judge wasn't entitled to reject the tribunal's findings. And on the facts of this case, section 19B1 of their act calls for the court to give deference to the factual findings of the tribunal. The policy of the act is to treat awards in the same way as it treats foreign arbitral awards, and then goes on to explain they are final and binding. And at the foot of 3143, this means the findings of fact are binding on parties and cannot be reopened except where there is fraud, breach of natural justice, or some other recognized vitiating factor. And then at 66, they reiterate a point which was made in a previous Court of Appeal case, the Assurancy Jasa case. And essentially, as you can see from the words that follow the quotation, that a tribunal has jurisdiction to decide any issue of fact or law, and including getting it wrong or right. And it's only, as they say, if a decision or decision-making process is tainted by fraud, breach of natural justice, or any other vitiating factor, any errors made by a tribunal are not per se contrary to public policy. And so at 67, they go on to explain when you can challenge on public policy grounds. And at the top of page 3145, they say in the second sentence, it's a question of law what the public policy of Singapore is. An arbitral award can be set aside if the tribunal makes an error of law in this regard. Now, in this regard, if you take a Soleimani type situation, is considering whether having found a contract was illegal or for a purpose which would be regarded as illegal, whether it was nevertheless enforceable. And so they then go on to say, in the present case, if the concluding agreement had been governed by Thai law instead of Singapore law, and if the tribunal held the agreement was indeed illegal under Thai law, but could nonetheless be enforced in Singapore because it was not contrary to Singapore's public policy, this finding, viz. That it was not against public policy to enforce an agreement which was illegal under its governing law, would be a finding of law which could be set aside under Article 34.2b2 of the model law. In other words, a Soleimani type situation. And you'll also want to review 69 and 70, but it's then important in understanding this decision to understand 71, because what the Court of Appeal did was go out of their way to explain that the approach that another High Court judge had taken, who had been following the first instance judge in AJU, was wrong. And at paragraph 71, the court refers to the Rockaby case. Now, it's probably, before we look at paragraph 71, I'd like you to turn up Rockaby so you can actually see what the case was about. And that is to be found at 3550 of the bundle. And the question in Rockaby was a question of statutory construction. So what Rockaby concerned was an allegation that the plaintiff was an unlicensed financial advisor and that a consultancy agreement with him was illegal for failing to comply with the licensing requirements set out in the Securities and Futures Act. Now, the arbitrator rejected that argument, and the award was challenged in Singapore on the basis that, on the grounds of public policy. Now, what you will see if you look at the judgment, if one looks at page 3554, paragraph 19, the judge said, having reviewed various authorities, including, I think, the AJU case, he said, I must determine whether the arbitrator came to an erroneous conclusion on issues relating to illegality under the SFA. If he did, I'd have to determine whether the illegality was of such a nature that to enforce the award would conflict with the public policy of Singapore. In other words, that's exactly the argument you can see in our case that has taken place. And if you then look at, you can see at 3554, he sets out the statutory regime. And if you turn forward to 3557, at paragraph 31, just the purpose of what I'm showing you is that this was all statutory interpretation. So at paragraph 31, the last sentence, he says, the question before me, whether the arbitrator had wrongly interpreted the relevant bits of the statute. And if you go to the next page, the last sentence of that paragraph, 32, says this is an issue of statutory construction. And then at paragraphs 33 to paragraph 40 of the judgment, the judge is considering Hansard and the various competing arguments as to what the statute means, and ultimately comes to the conclusion that the arbitrator was correct. But what he's doing is a de novo interpretation of the statute. And so if one then goes back, sorry to jump around, to AJU, having explained Rockaby, you go back to page 3146. So AJU, having considered the basis on which a court should intervene, where somebody is saying a tribunal's finding is wrong and that find because of public policy you should intervene. At 71, they say, page 3146, before we conclude our discussion of issue A, there's one other point we wish to make. This concerns Rockaby, which, like the present case, involved an application to set aside an International Arbitration Act award on the basis of illegality in the underlying contract. The arbitral award in that case stemmed from a consultancy agreement under which the plaintiff was to advise the defendant on its plan to secure a listing on Singapore's stock exchange. In the arbitration, the plaintiff claimed various sums allegedly owed by the defendant under the consultancy agreement. The defendant resisted the claim on the ground that the plaintiff was not exempt from the licensing requirements under the Act, as the advice given by him did not meet the criterion of being advice not specifically given for the purpose of making an offer for securities, etc. Accordingly, the defendant contended the plaintiff was an unlicensed financial advisor, therefore the agreement was illegal as well as null and void. The arbitrator ruled against that. The defendant applied to the High Court to set aside the award on the basis it offended the public policy of Singapore as it upheld an illegal contract. In dealing with the defendant's application, the court cited the High Court judgment, in this case with approval, and adopted the same approach, stating that in deciding the issue of illegality, it had the power to examine the facts of the case afresh. This is inconsistent with the approach which we have set out in this judgment. And so in our submission, properly understood, AJU takes a restrictive approach, not an expansive approach, and is not saying just because it is alleged that a contract was in breach of a statute, and the Securities and Futures Act obviously would be an important statute in Singapore. That doesn't give the court the right to review. And in our submission, this case is an exact parallel to our case, and the Court of Appeal's rejection of the approach followed by the judge in that case supports our position and indeed undermines the Supreme Court's erroneous reliance on AJU. And part of the submission that is made in this case is that essentially where the STC submission is that there is a distinction to be drawn between findings of fact made by a tribunal, those can't be reviewed, as opposed to findings of law, which potentially can be. Now, in our submission, you have to read carefully and understand what is being said in this case and indeed in the English cases. And the distinction is not between points of fact and points of law, so much as between points which have been determined by the tribunal on the merits, whether of fact or law, and the very narrow question, in the light of the determinations which have been made, of what the public policy there of Singapore is in relation to the award that has been made. And in our submission, properly understood, under Singapore law, as AJU shows, an award is not reviewable on public policy grounds simply because a court is invited to consider that the tribunal was wrong in its conclusion as to the legality of the underlying contract. And it will only be set aside under the public policy head of challenge if the contract at issue falls within that category of contract which will simply not be enforced because, in the light of the findings that have been made, it is palpably and indisputably illegal or contrary to morality, such as the contract in Soleimani. And if the tribunal holds that the contract is illegal under its governing law but can still be enforced, and so falls into error in relation to the content of what public policy is. But other than that, the court and the policy is, as borne out by Westacre and the the decision of Mr. Justice Coleman held in the Court of Appeal is that the court should show restraint and not interfere with matters that fall within the scope of the arbitrator's jurisdiction. And if one thinks about this case, and one of the reasons I showed you the provisions of the PPA, on our case, there is a dispute, which is what do the relevant parts of the PPA mean? And what STC says, well, that invokes public policy because it goes to the nature and scope, a mantra they repeat many times in their written case. But one has to ask, well, what is the distinction between a case which is concerned with the construction of Section 3.2 and the regulation with another case where, for instance, a tribunal holds that a contract was not a major contract because the reasonable estimable value was below the threshold. Now, the STC comes along and says, no, it was we now want to say the reason that the tribunal was wrong about that. On their case, the public policy of Mauritius is impacted in exactly the same way. Equally, the point I showed you about a direct procurement. You could have questions of fact. What about the question where it's alleged, as it was here, that the procurement contract has been procured by bribery? Totally bad allegation which has been rejected and now abandoned. But why is that something which the STC accepts couldn't be reviewed, but a question as to what the PPA, what these bits of the PPA mean, that can be? Why is that something which goes to the fundamental public policy of Mauritius and not other points? And we say very simply that there is no principled basis upon which STC's argument works. Now, STC refer in their submission to 4 cases which are, as it were, out of the line of both the English and Singapore cases. They are Eco-Swiss, Claro, Accentuate, and a decision in the commercial court called SAS Institute. Now, obviously, because we're running out of time, I'm not going to go through those cases. But in our submission, none of those cases is concerned with the issue which you're concerned with and which AJU was concerned with, which is the question of whether or not a court should conduct a de novo review of an issue which has been determined by a tribunal within its jurisdiction. And so on this point, we submit that the Supreme Court was wrong to reconsider the decision on a de novo basis. And the judgment fails to recognize the cardinal principle of non-intervention and finality, and that a supervisory court is not entitled to set aside awards for errors of fact or law, given that statutes, all statutes, or certainly most statutes of any significance, can be said to constitute an expression of a state's public policy. It is difficult to see how, on the Supreme Court's approach and STC's approach, any principled restraint would be imposed on the power of review available under Section 39 2B2. Indeed, if the judgment of the Supreme Court is correct, every Mauritian arbitration award which resolves a dispute over whether there has been compliance with what is said to be an important statute would find itself vulnerable to de novo review. Such an approach is in clear conflict with the principles identified in sections 2A and B of the International Arbitration Act, with the principle of separability in Section 20, and with the highly restricted grounds of challenging an award contained in Section 39, and indeed with both the English and Singapore authorities. And so in our submission, and I see the time, the Supreme Court should never have got involved in this question, and in any event, for the reasons I've already given, they got it entirely wrong when they did get involved.
Lord Leggett has a question.
Before you finish, Mr. Hurd, suppose the arbitrator had decided the question of interpretation the opposite way, in favour of STC, but he'd then gone on to hold that it wasn't sufficiently serious to be contrary to Mauritian public policy, and therefore he wasn't going to, he was going, if that was the argument made before him. I know it wasn't, but suppose it had been. Would that be the sort of question where the Mauritian court could take a different view from him?
Yes.
But where accepting his findings, but in his construction of the Act, taking a different view about its significance, public policy.
That is precisely the type of situation that it can, because that's then a question of what the public policy of Mauritius is in relation to the enforcement of an illegal contract. And so that's not a question which the parties can, as it were, abrogate to themselves. That impacts upon the public policy. Now, and so, and that's, I mean, that's a Soleimani type situation. I mean, the difference in Soleimani is it was sort of clear beyond really any sensible argument that once you had a contract to do something such as smuggling, or you have a contract which is about drugs, importing, selling drugs, all that sort of thing, those are the examples you find given in the authorities. But here we accept that if the tribunal had said this was a breach of the PPA, but it doesn't matter because as a matter of public policy, there's no reason why the contract shouldn't be enforced, that would be a question which the court would be entitled to review and consider for itself.
Thank you.
Thank you. Mr. Moulan.
I do apologize, my lords, my lady. I just had a point since we're going to come to my part. One of the issues I need to deal with, unfortunately, is an argument that we are precluded from running the public policy point I'm going to be addressing. And because I anticipated we might be short of time, we've got a very short note with the references to rebut that argument. I was wondering whether it might be possible to, or if the board would be willing to receive that so you can look at it over lunch rather than spend the 30 minutes I have, which would be probably better spent looking at these substantive principles of law.
If you send the note, to the board now, that would be helpful. Thank you very much, Mr. Moulan. Mr. Hard, thank you very much for your submissions. We will hear Mr. Moulan after lunch. We will now adjourn.